They thought I was just an old farmer with dusty boots and a quiet voice. They were wrong. My name is Daniel Harper, and my family owned 3,500 acres of farmland in Texas for over 100 years. My great-grandfather bought the land after returning from World War I. My grandfather built the first barn with his bare hands. My father raised cattle there. And I grew up running through fields of wheat that stretched to the horizon. That land wasn't just property. It was blood, it was memory, it was legacy. So when the Cedar Ridge Homeowners Association claimed they had legally purchased my farm, I laughed. For about 5 minutes. Then I saw the paperwork. It started quietly. One afternoon, I noticed survey stakes hammered into the ground near my southern fence line. I assumed it was a mistake. Maybe a county inspection. Maybe someone measuring utility lines. The next week, bulldozers arrived. I drove my truck down to the edge of the property and found men in hard hats clearing trees. I asked who authorized it. Cedar Ridge Development, one of them said casually. We start phase 1 next Monday. On whose land? I asked. He looked at me like I was confused. Sir, this land was sold 3 months ago. Sold, 3 months ago, to an HOA. I went straight to the county clerk's office. And there it was, a deed transfer recorded under my property's legal description. My signature was on it. Except it wasn't. It was forged. Someone had filed fraudulent paperwork transferring my 3,500 acres to Cedar Ridge Residential Association, Inc. The board had then partnered with a development company and already pre-sold lots. And here's the worst part. They had title insurance. They had bank financing. And they had lawyers. When I confronted the HOA president, a man named Richard Collins, he smiled like he was explaining something to a child. Mr. Harper, the transaction was properly recorded. If you have an issue, take it up in court. Court. You see, most people don't understand how dangerous that sentence is. Court takes time, months, years. Meanwhile, construction continues. By the time I filed suit, they had already built roads. By the time the preliminary injunction hearing happened, foundations were poured. By the time the judge ordered a temporary halt pending investigation, 42 houses were standing. 42. On my farm. The forgery investigation took 8 months. The signature was proven fake. The notary stamp was fraudulent. The seller's representative, listed on the paperwork, didn't exist. But Cedar Ridge argued something else. They claimed to be good faith purchasers. They said they relied on recorded documents. They said the homeowners who had bought the houses were innocent third parties. The court agreed, partially. The deed transfer was void. The land was legally still mine. But because the homes were built and sold to individual families who had mortgages, the judge ruled the situation had to be equitably resolved. Translation: it was a legal nightmare. The HOA proposed a settlement. They would purchase the land properly now, at agricultural value. Agricultural value. They were offering me the price of grazing land for property they had already subdivided and turned into a luxury gated community with swimming pools and tennis courts. I refused. Richard Collins warned me quietly after the hearing. You'll never win against an entire neighborhood, Mr. Harper. Think about your reputation. That's when I stopped thinking like a farmer. And started thinking like a businessman. I hired the best real estate litigation firm in the state. Not cheap lawyers. Not small town council. Sharks. And they found something interesting. When Cedar Ridge incorporated their HOA, they made a critical mistake in their governing documents. The covenants, conditions, and restrictions, the CC&Rs, had been improperly filed. Specifically, the legal description attached to the HOA declaration referenced my original farm boundaries. All 3,500 acres. Not just the 42 developed home lots. Which meant something extraordinary. Because the original deed transfer was void, and because the HOA's governing documents tied all properties to the master tract, which legally remained mine, every home built was technically situated on land I owned, subject to a defective subdivision. The homeowners didn't own the land beneath their houses. They owned structures sitting on my property. Now here's where most people would get angry and start evicting families. I didn't. I did something smarter. Under state law, improvements built on another person's land without valid title fall under a doctrine called betterment. Which meant the homeowners could either remove the structures at their own expense, or purchase the land from the true owner, me. But here's the part Cedar Ridge never anticipated. Because of the defective filing, the HOA itself had no lawful authority to levy dues, enforce liens, or manage common areas. Their entire governance structure was legally compromised. And that made every mortgage lender very, very nervous. I didn't threaten anyone. I sent letters, polite letters, to every homeowner. I explained the court ruling. I attached copies of the voided deed. I included a clear, fair offer. Each homeowner could purchase the land under their house and proportional share of community space at current developed market value, not agricultural value. Or we would proceed under statutory remedies. Within a week, chaos erupted. Homeowners confronted the HOA board. Banks demanded clarification. Title insurers panicked. Richard Collins tried to intimidate me again. "You're holding families hostage." "No," I said calmly. "You did that when you built their homes on stolen land." The lawsuits multiplied, not against me. Against the HOA. Homeowners sued the board for misrepresentation. Lenders sued for negligence. The developer filed cross-claims. Insurance companies sought rescission. Cedar Ridge collapsed under legal fees within 3 months. And then the phone calls started. Not from lawyers, from residents. A retired couple who had sunk their savings into their dream home. A young family with a newborn. A teacher who had moved to the community for safety. They weren't my enemies. They were victims. So I made a decision. I restructured the entire deal. Instead of forcing individual purchases immediately, I created a land trust. I transferred the 3,500 acres into Harper Legacy Holdings, LLC. Then I offered homeowners long-term, renewable 99-year ground leases at fair rates, significantly lower than purchasing outright. Stable, predictable, legal. The lease payments would fund maintenance of shared areas, effectively replacing the HOA, but transparently and lawfully. The homeowners voted, without the old board, to dissolve Cedar Ridge HOA and enter into agreements directly with my company. Richard Collins resigned quietly before the criminal investigation into the forged documents concluded. Yes, criminal investigation. It turned out the forgery traced back to a consultant hired by the developer, but emails showed the HOA board ignored red flags about irregularities in the transaction timeline. Negligence, at minimum. Fraud, possibly. In the end, here's what happened. I kept ownership of the land. Every homeowner got secure legal rights to their property. The corrupt HOA board was dismantled. And my family farm, it still exists. The northern 2,800 acres remain agricultural. I lease portions to neighboring ranchers and run cattle just like my father did. The southern 700 acres became a master-planned community, but under terms I control. People ask me if I regret not just taking the settlement early. Selling out, walking away rich and quiet. But money wasn't the point. They tried to erase a century of history with forged paperwork and corporate arrogance. Instead, they learned something simple. You don't steal